Welcome back. This is our Chapter 7 Intellectual Property Update. We'll welcome Dolores DeBella, who's been a frequent guest for us almost every year uh, here. And Zach, we're going to call on you, and thanks for helping put this PowerPoint together, these update links, which are terrific, tracking Chapter 7 of the book and some updates and intellectual property trademark updates. You know, Darren Heitner, who's actually sponsoring a placement for us again this year, deals in this area of trademark and you know, trying to own that which is unique and specific, and take us through the THE Ohio State application denied. Tom Brady, terrific, Tom. What's going on here? And thanks for the links, and Zach, take it from here, please. Thank you.
No worries. So in Chapter 7, we talk a lot about this right of publicity that's been developed for players, and a bunch of players have this right of publicity. It's ability to basically profit off your image and likeness. And right here, we're seeing that right kind of intersect with a different law, which is the trademark laws, right? And so what this shows is that these rights of publicity, they're not unlimited. There are restrictions for them. And we see this especially in these three cases. We first have Ohio State trying to trademark the, they were denied. Tom Brady trying to trademark Terrific Tom, they were denied by the USPTO because the USPTO said it was too similar to Tom Seaver, the Mets pitcher's name. And we have MLB Shane Bieber, who got his not Justin trademark opposed, amusingly, by a shoe company, some shoe company called Justin Boots. Apparently, the USPTO said it was too similar to them, and therefore they could not trademark this either.
Thank you. And this goes back to development of the right of publicity. This is page 204 and following, right, teasing it out even further. Additional lawsuits over intellectual property rights. Greek Freak Brand, Kawhi Leonard. We touched on that in the 2019 update. And we also touched on the Jordan case in the 2019 update, but take us through this before we get to sort of team and league rights, which is the rest of Chapter 7.
Yeah, I think the key here is, again, showing how you can contract away your right of publicity. Kawhi Leonard was under contract with Nike when they developed the logo. And so they ruled that even though Kawhi Leonard played a role in developing the logo, that since he was under contract with Nike, that Nike controlled anything that came out of that relationship, and therefore Nike owned that logo. Jordan's case is an interesting one where Chao Dan, which is a translation of Jordan's name in Chinese, someone in China created a gigantic sportswear company called Chao Dan. And Jordan, I believe it was around 5 to 10 years after the creation, after Chao Dan had become this huge business in China, sued saying that they should not be able to use his name. And surprisingly, the Chinese courts, the highest court in China, sided with Jordan, saying that it was right. It was a trademark violation.
But there, it was sort of a Solomonic result, though, right?
At the end, even though they said they violated his trademark, they ruled that the profits that Chao Dan had made were still going to be kept by him. Chao Dan is an interesting case where most people were introduced to Michael Jordan through that company, actually. Jordan was not as popular before the company started, so there were some interesting rulings that came out of that case that were pretty fact-specific.
Thank you. We're now getting into publicity rights and commercial products at page 208 and following, again, before we get to the team and league exploitation of the rights and some of the different defenses and even the use of the Lanham Act at page 211 when it's appropriate. But this tattoo case is ultimately, this is Solid Oak, and we've got some good links to it. You know, different WWE case. I mean, how do you own your tattoo likeness? It really wasn't LeBron himself, although he spoke out in you know, defense of his owning his tattoo in a video game. Take us through these. I mean, you know, how far can name, image, likeness rights extend, and when does it become a de minimis use that an artist is allowed to use in creating a video game?
Yeah, so these were interesting cases because, like you said, Solid Oak is the tattoo company, and they own the copyright technically over these players' tattoos that they made. So I believe it was 4 players. It was LeBron James, J.R. Smith, and a couple others. And so they sued the parent of NBA 2K, Take-Two Interactive, for using these tattoos in their video games, saying, you can't use them. You didn't get our permission, even though they had permission from the players themselves. They didn't have permission from the tattoo shop, and they said, therefore, you shouldn't be allowed to use it. And the court ultimately ruled that no, this is not a violation for a multitude of different reasons. First, they held it was de minimis use, and I think that was partially because this was only 4 out of 200 players that had these tattoos. They also said it was fair use because this was something where if you give a tattoo to a player, they probably have a non-exclusive right to use their body / their likeness any way they want. And so the court ruled that if you give a tattoo to a player, that just seems reasonable that they would do so, and therefore it shouldn't be a violation. Though, having said all of that, we have this very similar WWE case involving Randy Orton, where the courts are seemingly going in the other direction. They haven't settled, they haven't come out with a decision yet, but it seems very positive in this side towards a much more pro-tattoo shop case.
Awesome. And let me just say, this is bargaining away the right of publicity. Nice transition to page 212 and following. And we have each of the three leagues, group licensing regimens there through and including page 217. And there is a reference to the Jordan cases, including the one Zach just updated us on at page 271 under NBA Association publicity rights. So now that takes us to the DirecTV lawsuit. There's been a lot of action here. We summarized it when this book was published, and that's at page 367 and following. And who wants to pick up the trail there? There's a footnote that'll tell you ultimately it's still alive. It can't make the NFL too happy. The facts are set forth at 367. Who wants to pick up that trail for the update? Zach, do you want to stay with that one?
Sure.
Okay,
so
thanks.
the DirecTV lawsuits were this, I believe it was around 20 lawsuits that were filed against the NFL and DirecTV for basically their Sunday ticket package, saying that it violated antitrust laws because they were the only ones allowed to broadcast it. Pretty similar to Garber and Lauman.
Yes.
The claims were pretty similar to those two cases. But in this case, the Ninth Circuit actually ruled that it does break antitrust lawsuits. And so right now it's up for repeal. Right now the Supreme Court might review, but as of now, the suit was successful, right? And so that's a very big deal given just how much money is at stake with these TV deals. There's billions of dollars in here.
Absolutely, and Lauman and Garber will remember, that's the famous settlement, MLB, that perhaps their antitrust exemption didn't protect them. That's why they settled when, Judge Heinlein felt like the antitrust exemption did not extend to broadcasting. And there's a study guide on that as well in the back of the book. It takes us all the way back to chapter 3. Okay, Supreme Court may review. Very interesting. And again, if Dolores can, DeBella, when she visits with us, I'm sure she'll have their best defenses available to her in the NFL legal department. Finally, single entity status. Now we get back to, how can a single entity conspire with itself so as to collude, so as to monopolize? We've been around this even on the ancillary restraint in esports when we talked about NBA 2K possibly being ancillary restraint violation by controlling the NBA controlling NBA 2K, but XFL went the single entity route. MLS and UFC single entity route. Again, we touch on this as being, a way around an antitrust case, because how can you conspire? This is a single entity question. Does not conclude the antitrust analysis. Perhaps Fraser v. MLS, single entity structure at page 230 and 231, and it really keys off of page 228 in the American Needle case, which was a unanimous Supreme Court decision saying the NFL was not a single entity and therefore was subject to antitrust scrutiny in its licensing operation, much like Salvino in MLB, which MLB was found to be under antitrust scrutiny. So why is this the preferable route? MLS, the old Arena Football League, why is that the preferable route to go? XFL? And maybe Aaron, I'll call on you because you have worked with Chris Duberter, works for DC United, and is this an absolute immunity after American Needle, and is that why the single entity status is so immune from antitrust attack?
Yeah, I think it's close. I wouldn't say it's absolutely completely immune, but I do think it's definitely the best route to go because, like you said, multiple entities, can, I'm sorry, if it's a single entity, cannot conspire with yourself. Multiple entities can conspire with each other. Therefore, single entities would not be subject to antitrust scrutiny. Obviously, that's kind of the thought process in going through this. Obviously, there are challenges, and if there's certain independent decision makers within the single entity, it may be subject to scrutiny as well. It is kind of more of a fact-based inquiry occasionally or sometimes, but for the most part, single entities, as they're set up here and strategically set up how most leagues would, XFL, MLS, and UFC are prevented or not subject to antitrust scrutiny because they are a single entity, at least under Section 1.
Okay, and we haven't put it on the update, but Davis and Dreyer are important cases to understand. Their textbook supplement has good summaries of those two cases, juxtaposing a video game versus archived rights. Let's just rehearse that. I mean, archived rights, Dolores is very eloquent about archive rights, greatest games, that intellectual property is part of the group license, essentially. Let's just say that I'm leading the witness, right? As opposed to using, in a video game using a name, image, likeness. Let's just juxtapose those two as a final point, Davis and Dreyer. Aaron, maybe I can stay with you on that one.
Yeah. So archive footage, very clearly part of the league-owned and group licensing program. So it's owned there by the league itself. Dreyer, not so much. On the other hand, independent player publicity rights, name, image, likeness. If it's not in the group licensing program, would then be subject to their each individual, exploitation as individuals.
Okay, and we've got Dreyer at page 380, and Davis, there's a very long supplement on that, and that starts at page 388 in the book. So I think that'll do it for now for our Chapter 7 update. Anything else, Zach or Ryan? If not, we'll sign off and look forward to seeing you back in class. Thank you very much for your continuing attention.